Good morning. My name is Josh Blackman. I'm the president of the Harlan Institute, and it's my honor to welcome you to the October term 2022 the Harlan Institute Ashford Virtual Supreme Court competition. This year, we are mooting the case of Students for Fair Admission versus the University of North Carolina. This is the first match of our semifinal round. The first team we have is from Creekview High School, Audrey Case and Dawn Kim. And the second case from Lake Oswego High School in Oregon. And we have Eliana Choi and Grace Walmuth. Okay. And with no further ado, petitioners, you have 10 minutes. Begin whenever you're ready.
May it please the court. My name is Audrey Case, along with my co-counsel, Dawn Kim. I represent the petitioners, Students for Fair Admissions.
The question presented today is whether the court should overrule Groda versus Bollinger and hold that institutions of higher education cannot use race as a factor in admissions. It should for the following two reasons. First, the 14th Amendment historically prohibits racial classification, and Brown versus Board of Education upheld this principle of race neutrality. Second, racial classification failed under strict scrutiny. First, the 14th Amendment historically prohibits racial classification. The Equal Protection Clause depicts the intended race neutrality of this amendment. Driven from the 1866 Civil Rights Act, the Equal Protection Clause extended the equal protection of the laws to all citizens regardless of their race, color, or previous conditions of servitude. At the time of this act's enactment, the framers not only expressed concern toward the newly freed slaves, but also the persecuted white Unionists in the South.
This spurred the question of whether the amendment was aimed purely towards the protection of American citizens of African descent, to which Senator Bingham clarified that it is proposed as well to protect the thousands of loyal white citizens of the United States and protect them also from banishment. Based on such dialogue, this court's remark in McDonald's that the 39th Congress was intent upon establishing a broader principle than would have been necessary simply to meet the particular and immediate plight of the newly freed Black slaves was correct.
Very good. If I could just jump in here. And if the other team, I'm sorry, I forgot your mind. If you just turn your camera off and your mic off, that way we have less going on the screen. The respondents, thank you so much. So my question for petitioners is, you mentioned some of the legislation that was enacted in the 1860s. Can you just mention what some of those laws were and what they did, please?
Yes, Your Honors. The Freedmen's Bureau helped establish schools for African Americans. Also, one law gave African American women and children resources as well.
All right, so we have these laws that gave benefits to African Americans, as you say. Isn't that kind of like a racial preference, the sort of thing being used by the University of North Carolina?
Your Honors, no, Your Honors, these laws were consistent with the 14th Amendment because the 14th Amendment allows the citizens once denied rights. For a bit of context, at the many laws specifically targeted only African Americans at the time, because at the time of the 1860s census, there was only the differentiation between white, Black, and mixed race between those two. So at the time, those two were really the only two demographics at the framers' minds. And even then, they used clearly race-neutral terms in the amendment itself. So such benefits would have been the same for any other races. Mm-hmm. And so therefore, this court's remark in McDonald's that the 39th Congress was intent upon establishing a broader principle than would have been necessary simply to meet the particular and immediate plights of the newly freed slaves was correct.
To add on to what my co-counsel said, because of the legislations that were passed that tended to help those who were in need of that assistance, because of the race neutral language that was used, it just further proves the intent of race neutrality in the amendment.
Mm-hmm.
Further, the landmark decision Brown declared that.
If I could just jump in here. So let's say the facts are a little bit different. Right? Let's say that the University of North Carolina only provided benefits to Black students. Would that be consistent with the legislation from the 1860s?
No, Your Honors. Right now, considering that the circumstances would have been same today back then, just because providing benefits based on race is not inconsistent with the 14th Amendment. Right now, everyone has an equal opportunity to apply to universities.
I think you've answered my questions. I can let my colleagues pose questions.
Yes, I have a question. Do you not think that the policy itself actually meets strict scrutiny? Is there not a compelling government interest in making sure that our schools are diverse?
UNC achieves its compelling interest through the least intrusive means, or must meet the interest through the least intrusive means or the least restrictive means. Grutter defines their compelling interest through a critical mass, defined by reference to the educational benefits that diversity is designed to produce. Fisher expands upon this definition by reference by an adequate representation of minority students so that the educational benefits derived from diversity can actually happen. Under Grutter's arguments, race-based benefits will always be necessary to achieve this interest, rendering it impossible to set an ending point to the plan. Fisher's expansion on Grutter sets the never-ending time limit impermissible, which requires that a narrowly tailored plan is limited in time and the university use periodic reviews to determine whether the racial preference are still necessary to achieve the student body interest.
Further, a little bit about the narrowly tailored aspect of the strict scrutiny test. Where exactly does the university's admissions process fail to narrowly tailor?
Your Honors, Grutter requires that universities consider available alternatives, but that they do not have to exhaust every single one. However, since Grutter, many more universities without race-based affirmative action have been able to maintain their racial diversity. For instance, data from the IPEDS reveals that the University of Oklahoma, for example, remains just as diverse today, if not more so, than it was when Oklahoma banned affirmative action in 2012. And therefore, such developments since Grutter allows this court to reconsider Grutter's ruling that there are no workable alternatives to race-conscious affirmative action policies, rendering it.
Let me jump in if I can. So you mentioned Oklahoma's banned affirmative action. I know Michigan has banned affirmative action. California's banned affirmative action. It seems the states have the power to get rid of this if it's so bad. Why should the U.S. Supreme Court intervene and stop all 50 states from doing this if federalism can work and each state can choose for itself what policies it adopts?
Well, Your Honors, because racial classification is so odious in nature, the Supreme Court has a right to intervene if it deems any type of racial classification to be unconstitutional.
I know we can intervene, but why do we have to though? Why can't the political process take care of this?
Your Honors, if it happens, if such the federal government should intervene because the federal government must intervene because racial classification, if one state deems it unconstitutional and one state deems it constitutional,
then when there are different states with such different opinions, it could affect the interstate relations, since these are elite universities and renowned universities as well. It would affect interstate relations in that sense, and therefore it is under the federal government's jurisdiction as well.
Second, racial classification is not the least restrictive means, for it is an arbitrary proxy for diversity. For instance, UNC and Harvard's category of Hispanic includes indigenous immigrants from Latin America whose first language, surnames, and ethnic and cultural backgrounds are not Spanish.
Also, their classification of Asian also aims to encompass its cultures and nations into one single category. The term Asian is extremely broad and masks 6 different regions. Race-based affirmative action programs essentially disregard this cultural diversity and operate under the stereotype that people of similar races share similar experiences. Racial diversity, while it is certainly an aspect, is an arbitrary proxy to use to achieve educational benefits that derive from overall diversity and not the least restricting means of achieving it. Your honors, I see that we are running out of time. May we quickly finish up our thoughts?
Yes, you may.
In conclusion, institutions of higher education cannot use affirmative action because the 14th Amendment prohibits racial classification and affirmative action fails under strict scrutiny. It is for these reasons we pray that this court overruled Grutter versus Bollinger.
Okay, thank you so much. Okay, if petitioners please can go on mute and turn off your camera. And if respondents can please turn your cameras on and your microphones on. You'll have 15 minutes. Begin whenever you're ready, Counselor.
Chief Justice, may it please the court. I am Eliana Choi, and I'm here as my co-counselor, Grace Wilmoth.
And we are here and we plead you to find that the University of North Carolina admissions policy is consistent with the 14th Amendment of the U.S. Constitution. So we are asking the court to deny the petition.
First off, the original intent of the 14th Amendment and the Equal Protection Clause was always to protect minority rights. When introducing this amendment to the House, Dada Stevens, a chair on the Joint Committee of Reconstruction, stated, quote, "Whatever law punishes a white man for a crime shall punish the black man precisely in the same way and to the same degree. Whatever law protects the white man shall afford equal protection to the black man," end quote. In this quote, he very explicitly states race, which acknowledges the difference between the treatment of white people and the treatment of black people in this time period. The reason why the 14th Amendment and Equal Protection Clause were necessary was because of the many oppressive laws against black people during this time period, such as the Dred Scott decision and Jim Crow laws. And this amendment was passed to combat these oppressive laws and systematic racism against this people.
Additionally, the petitioners mentioned that it should not be considered under strict scrutiny, but the Supreme Court held that all race-based classifications must be subject to strict scrutiny in Adirondack Structures versus Pena. An affirmative action is a race-based classification that is under strict scrutiny because it is both narrowly tailored and has compelling government interest. The narrowly tailored standard is met because there is no other adequate policy that would allow for a critical mass of minority groups, and affirmative action is an effective mechanism for extending equal opportunity to students from groups that have historically been discriminated against and systematically excluded from higher education systems.
Okay, Counselor, if I could interrupt you for a moment. We talked a lot about the 1860s, and maybe you can speak to the legislation that was enacted in the 1860s and how that might affect this case, please.
Well, one thing was the Civil Rights Act of 1864, which was passed in support of protecting minority groups. And if we look at previous precedent from that time period, we see multiple cases that are in support of protecting minority groups, and affirmative action upholds this under stare decisis. And that's why Grutter v. Bollinger is consistent with previous precedent.
And additionally, some of these the language in the Equal Protection Clause has been used to protect other minority groups other than Black people, such as Chinese people in an 1886 case, Yikwo v. Hopkins.
I have a question. You said that there's precedent that upholds affirmative action. What is the precedent that does that?
It does this in Bakke, Grutter v. Bakke, Grutter v. Bollinger, and Fisher.
And I think the plaintiffs want to overrule those cases, don't they?
What was that?
I think the plaintiffs want to overrule those cases, don't they?
They do, but we don't believe that that's consistent with the 14th Amendment.
Well, maybe talk about stare decisis a little bit, since you mentioned the precedents. Why should the court stand by Bakke, stand by Grutter, stand by Fisher?
Well, obviously, recently we've seen with Dobbs v. Jackson that they have gone against previous precedent, but we believe that is an anomaly case that was important in returning the rights to the states. But banning affirmative action would be limiting states' rights and would give the federal government too much power in the admissions process. And we believe that affirmative action is heavily implied as legal through the 14th Amendment. Yet it isn't explicitly stated because this was not a consideration when the amendment was written, although it is implied.
All right, let me ask another question. Let's assume that, you mentioned the Civil Rights Act, your friends mentioned the Freedmen's Bureau Act. In the 1860s, there was good reason to use racial preference. We just had slavery, we just had a civil war, Reconstructions were really bad. The year's 2023, thankfully things are better, maybe not perfect, but they're better than they were 150 years ago. Maybe the need for affirmative action, in other words, maybe the justification for affirmative action is less today than it was 150 years ago. Maybe it was constitutional in the 1860s, but it's not so constitutional now. How would you respond to that position?
Well, there's still lots of racism present in our country today, and the effects of systematic racism on minority groups can still be felt. And there's statistics showing, according to the Board of Governors of the Federal Reserve System, Black and Hispanic households hold only 2.9 and 2.8% of the wealth, respectively, while accounting for 15.6 and 10.9% of the United States population.
If I can just pause you. So you mentioned Black and Hispanic people. Without question, Black people were enslaved and were subject to, the system of slavery and Jim Crow. Do other minority groups have a similar claim to that sort of historical treatment?
Yes, they do. They've been historically discriminated against and systematically excluded from institutions of higher education. So as Sandra Day O'Connor said, we're trying to create kind of a pipeline of diversity into the middle class. So we don't believe that affirmative action will be necessary forever, but we certainly do believe that's necessary now based on.
Do Asian Americans also have been subject to that sort of exclusion from institutions of higher education?
Definitely, with the Chinese Exclusion Act, and there's been acts against Japanese people during World War II. Asian Americans have also been subject to the systematic racism of the United States.
But UNC doesn't provide any racial benefits for Asians, do they?
But if you were to go with a race-blind application policy, then Asian American applicants might not be allowed to write about their identities in essays, which would erase part of their identities as an applicant and would negatively benefit them.
And we also believe that it's important not only for the minority groups, but also for all racial backgrounds to have affirmative action because it creates diversity, which is obviously a compelling government interest. And it's important because it has benefits for everyone by creating a wealth of ideas that aren't just one viewpoint.
Now, earlier today, you brought up Justice O'Connor, but if my memory serves correct, in her opinion in Gratz or Bakke, I forget, that she predicted a 25-year end to these sort of race practices in college admissions. Do you see this as a permanent thing that will exist within colleges, or is this to right some wrong and there is an inevitable end in the future?
Yeah, so we agree with Justice Sandra Day O'Connor, and she predicted 25 years, which would be in the year 2028. But looking at the statistics, we don't think that that is soon enough. We think that it's going to take more time than that, looking at statistics. And while affirmative action has increased that pipeline of diversity into the middle class, we still think that it's necessary for there to be affirmative action for longer to increase the numbers and make it more equal for everyone.
Can you also expand on how student body diversity is a compelling government interest?
Yes, we believe that affirmative action is a compelling government interest because it creates diversity. And there's three main reasons that we think diversity is important. The first one is that students won't feel as isolated as a minority on campus, and they won't feel as tokens or representatives of their specific race. Second, a critical mass will also provide educational benefits for every student there because more viewpoints will be given So there won't just be one view of like the Black race or the Asian American race. There will be a variety of different people from that race to represent them. And third, the critical mass was used to reduce negative stereotypes, which would continue if there's a continuation of diversity in college campuses.
Justice Day O'Connor, the 25-year cap on affirmative action, I believe was a way of narrowly tailoring to meet that compelling government interest. So if we were to extend the 25 years indefinitely or for a specific period of time, how do you propose that we narrowly tailor, and is the critical mass narrowly tailored to meet that government interest?
Well, Justice Day O'Connor said in Greta v. Bollinger that it creates educational benefits from student body diversity. And Justice Powell, in the same decision, his opinion was that the nation's future depends on leaders trained through wide exposure to the ideas and more students of diversity as this nation of many people. So with Justice Day O'Connor and her 25 years, we agree that it might only be necessary for a short time, but it's by looking at statistics that we can figure out the when.
Well, usually when we're talking about strict scrutiny, it's a very rigorous standard. And I think what I'm hearing from the university is trust us. Trust us. Usually with the strict scrutiny, it's not trust us, it's show us proof and give us a line. When will there be enough? What number are you looking for? What percentage of minority applicants will make you happy that you no longer have to use racial preferences? What's your number?
I think it's less about like the number of like minority applicants or acceptances. It's more about like social class in general, like as we talked about with like the pipeline of diversity into the middle class. I think when there's not such like wide disparity between like white Americans and Americans of like.
So let's just say North Carolina, say 25% Black population, right? Just I'm making the number up. And let's say you achieve 25% of your incoming freshman class was Black. Would that be enough? Would that be a critical mass?
We don't believe that there's a specific like set number, like 25%, or a certain number that will create a critical mass. I think it's important that there's like a critical mass, in our opinion, is defined as a group of students enough so that the students of their own race feel properly represented and that there's equal opportunity for them despite.
How do you know when we'll achieve? In other words, I mean, can you submit a report to the court saying what we've achieved it? I mean, how will we know when we get there?
As we mentioned before, I think it's more about like, rather than in like an academic setting, it's more about like the futures of those students and where they'll end up in the future, so that like in the future, like their children will have the same.
But what if we come back here in 50 years, forget 25, let's say 50 years, and you're still saying we're not quite there yet? At some point, does the 14th Amendment say, okay, you need to stop? We agree there's some logical stopping points of affirmative action? Is there any point we'll have to stop?
Well, I mean, obviously it's hard to predict the future, but the 14th Amendment doesn't establish a stopping point. So that's something that we're going to have to see exactly where affirmative action is going to lead us. And we see all the positive benefits that it already has. And we see with Proposition 209, the negative effects of it being taken away, and the negative effects this has on Black and Latino students in particular. So we think that there is no particular stopping point, but as of now, it's necessary until this systematic racism that has been built into the educational system begins to break down.
Let me ask another question. In Plessy versus Ferguson, Justice John Marshall Harlan famously said the Constitution's colorblind. What did he mean by that?
Well, Plessy v. Ferguson is where they decided like on separate but equal. And I think when he said the Constitution is colorblind, I think he meant that like it's okay if like as like for segregation, but then Plessy v. Ferguson was overturned in Brown v. Board of Education.
Yes, and in Brown v. Board of Education, that was with the intent of protecting minority groups. And Brown v. Board does not prohibit race-conscious affirmative action because it declares that segregated schools are unconstitutional under the 14th Amendment, and it demonstrates the commitment of diversity that has.
I don't
been
think that's what Brown said, and it might be a modern spin on Brown, but it said you can't have racial segregation. You can't use racial classifications. I think you're reading Brown through a modern lens. It wasn't about diversity. It was about you can't have segregation.
Well, the intent was of protecting minority groups, as is
I
affirmative
think it's
action.
a protecting protection of laws.
What was that? Sorry.
I think Brown was about ensuring equal protection of laws. It wasn't about protecting certain minority groups.
We disagree with that. We think that it was because by desegregating schools, as Justin Warren said, it generates a feeling of inferiority in the community that may affect the hearts and minds in a way unlikely to be ever be undone. And by creating it did create more diversity because there were no longer segregated schools. There were no longer pure white schools and pure Black schools.
I think you're running really low on time, but is it y'all's position that Brown and Grutter can both coexist? Because on their face, they seem to be doing close to opposite things.
We believe they can coexist as both in their intent was to protect the rights of minorities. And I see we're running low on time. So
Finish your thought.
Well, affirmative action prevents segregation on the basis of race by working to eliminate unlawful discrimination, and it confirms the importance of considering race as a factor in the educational institutions. And over 40 years of precedent, including Bakke, Bollinger, and Fisher, have upheld affirmative action in college admissions and has proved that it is not at odds with Brown v. Board of Education.
All right, thank you so much, Counselor. Petitioners, please come back on camera, return your microphone, and you have a 5-minute rebuttal period. Okay, whenever you're ready to begin.
May it please the court. There are two aspects of the respondent's argument that we would like to address. First, all the historical evidence respondents cite actually prove that the 14th Amendment is race neutral. Second, non-minority applicants should not bear the burden of dispensing the systemic barriers due to racism. To begin, the language of the amendment itself is so clear in that any type of racial classification is not allowed. The Privileges and Immunities Clause, for instance, states that there shall be no discrimination, that states cannot abridge the privileges or immunities of any citizens.
Further, the Freedmen's Bureau Section 4 specifically authorized setting apart for freedmen and refugees lands for the use of loyal refugees and freedmen. The emphasis on loyal refugees again reflects the author's concern about the persecution of Union men in the South. In fact, according to historian Paul Moreno, legislative history points to evidence that refugees were added in part because of concerns that the proposed legislation was seen by some as race-based.
And to answer the question of why the federal government should intervene on behalf of states for affirmative action, the 14th Amendment itself requires that it is on the federal level. It requires that the federal government can intervene, can and should intervene.
So if I could interrupt you. So I asked your friend to sort of discuss Justice Harlan's dissent in Plessy, where he said there's a colorblind constitution. How do you understand Plessy?
Your Honors, Plessy does require that the government should be colorblind.
This is Harlan's dissent, not the majority. I meant to say Harlan's dissent. I'm sorry if my question wasn't clear.
I'm sorry, Your Honors. I'm not sure if I understand the question.
Can you discuss Justice Harlan's dissent in Plessy versus Ferguson, please?
Your Honors, we're not sure if we understand your question correctly.
So Justice Harlan dissented in Plessy. You familiar with the dissent?
No, Your Honors.
Okay. Well, then maybe you can discuss Brown versus Board of Education. How do you understand Brown and your case? How does Brown affect the affirmative action debate?
Your Honors, Brown clearly prohibits considering race at all in education. Its position is clear in that, and it says, quote, segregation of children in on the basis of race in public schools deprives children of minority applicants of equal educational opportunities. Respondents' brief focuses on the desegregation aspect of Brown, however, and relates that to UNC's policy. However, Brown never permits giving racial preferences to achieve that, and prohibits using race at all in education.
To add on to what my co-counsel just stated, as Parents Involved states, the only way to end racial discrimination is to end racial discrimination. As the respondents pointed out, although systematic racism is indeed an issue, using racial discrimination to combat racial discrimination is contradictory and counterproductive to in the way that affirmative action is trying to achieve its goal.
Further, Richmond ruled that that universities cannot use societal past discrimination as a compelling interest, and that only past discrimination in the university level can justify using racial classification.
But Council,
But UNC doesn't.
Council, I'm sorry to interrupt, we're running a little bit short on time. We'll talk about stare decisis a bit. Why should we overrule Grutter?
As Dobbs v. Jackson implemented the five points on which to overrule precedent.
I think they're tech glitching.
And your honors, brother meet all those precedents. I see that we're running out of time. Make sure
Can you repeat what you said?
Your honors,
I'm sorry. I said there was some tech glitches. I think I heard most of what you said. Thank you so much for that. Okay.
Thank you so much.
Okay. So if the petitioners, please, respondents, please come back on camera. So I want to say congratulations to all of you. This was not an easy task, and you did really well. I threw some really hard questions at you. Abby threw some really hard questions at you. Daniel threw some really hard questions at you. This is what we'd ask of law students, and you participated at such a strong level. You should all be very, very proud of yourselves. I do this every year, and it so blows me away that a bunch of 16 and 17-year-olds and 15-year-olds can pull this off. This is truly remarkable. Abby and Daniel, anything you'd like to share with our students?
Yes, I'll go. First of all, you guys did amazing. I'm in moot court on the law school level, so you guys did wonderfully. Your briefs were wonderful. I think that it takes such bravery and commitment to do this. The only thing I can say, simply because I'm on moot court and just from an oral argument standpoint, is just work on what's called responsiveness. So when people ask questions, responding immediately with yes or no, and then answering the question. It's just really important because it really gives clarification as the listener, because I'm like, okay, trying to find exactly what it is you're saying. So if you answer with yes or no, then I know your position, and then you can give the reason. But other than that, I'm truly impressed. You guys are amazing.
Daniel?
I did this exact same problem in my last moot court competition last semester, and y'all's legal writing was way better than some of the briefs I read for this actual competition that I went to, and y'all's writing was miles ahead of where I was at in high school. So that's very impressive on itself. Great job answering the questions.
And let me get some specific
really fun to
feedback.
watch.
Oh, I'm sorry, Daniel. There was a bit of a delay. I'm sorry I spoke over you. I apologize.
That's all right.
I'll give you some specific feedback. What I really liked is your what we call courtroom demeanor. You're all very respectful. You said, yes, Your Honor, no, Your Honor. Every sentence began with Your Honor, no, Your Honor, which is very hard because you don't want to say that. You have to like force yourself to say it. Also, I like this sort of give and take between the team members. When one team member maybe wasn't on the right footing, the other one jumped right in. And it was pretty natural. There wasn't like this sort of artificial, like you go, no, you go. Right. It was pretty natural. Also, for both teams, I asked you something you didn't know. I knew it was going to happen. In fact, my goal is to find the thing you don't know. That's what I try to do with the questions. And you handled it well. You said, Your Honor, we don't know that case. Fine. Always be honest with the court, right? If you don't know, say, Your Honor, I am not familiar with that case. And then say something else, right? Say, but this other case, da 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 da. right? So that's very useful. I tried to push you, so especially the respondents. I tried to push you on when will there be enough diversity, and you did not cave, right? I kept trying to push you and say, will 25% be enough? 50 years, whatever number I give you, and you did not flinch because you know why. The second you say yes, Your Honor, that's enough. I've nailed you. You're toast because then your entire game is up. Then isn't that a quota, right? Isn't 20% a quota? You can't say that. So you resisted my question respectfully, but you resisted my question respectfully. And if you actually listen to the argument of the Supreme Court, it went about that way, where the lawyer was like just pushing back. I'm also it's a very sensitive, difficult subject. I mean, you're all in high school now. You'll be applying to college either this year or next year, depending what year you are. So this is going to affect you directly. This is going to directly affect the way you have your college experience. So I thought you handled it very well. So I want to say thank you so much. And always, if you have any questions, you can find me, reach out to me. Always happy to give mentoring. Your coach has been in this competition for almost a decade. I know them very well. So I'm happy to work with you if anything you need. Do you have any questions for us about law school or anything else?
No, Your Honor.
Anything from the other team? Oh boy, they're frozen. Oh no, I hope they can hear us. All right, well.
I do have one question.
Yes,
So
go
when
ahead.
preparing oral arguments now,
Is it okay now?
Please go
Are we
ahead.
unfrozen?
Yes, I
okay.
can hear you.
When preparing oral arguments, should we get most of our content from the brief, or is it better? Is it better to use
I'm
all?
pointing to Abby. She can't see me right now, but I'm pointing to Abby.
Okay. Okay.
Yes, no, don't just argue what's in your brief and recite your brief. It's a very different format. And I know this because I write the brief and then I have to turn that into an oral argument, and it's really very, very different. In oral argument, you want to get to the point, you want to give your 2 points, and you want to argue. You have to make it very concise. And so in your brief, you have the opportunity to really expand on your argument and really give a lot of context. And in your oral argument, you don't. So you want to relate the cases that you're using, the precedent that you're using to your set of facts very precisely.
So, like in your oral argument, if it makes sense to add statistics that you didn't necessarily add in your brief, that's okay. Like,
Yeah, absolutely.
expand on things that you said in your brief, but still keep it short. That's difficult.
Absolutely.
To find the balance, but okay.
Yeah, you don't have to stick to your brief in your oral argument.
Interesting. Okay.
And should we do we usually change oral arguments every round? Do people?
I'm sorry, what's your question?
Or like, do we edit and change? How much should we change our oral argument?
Oh,
from
you'll get
each
better
round?
because here's what's going to happen, right? After this for semifinal round's over, I'm going to share the video and you're going to watch it and you're going to say, oh, I should have said this. No, I should have said that.
Yeah.
Right, Daniel Nabby, you listen to yourself and then you get better. And it's been my
Really important thing is go back and listen to the questions that the judges asks and figure out what you would say, because the best way to get better at this is just to get reps in answering questions and being affirmative with the judge. Yes, Your Honor. No, Your Honor. That sort of thing.
Yeah, you're absolutely going to change from oral argument to oral argument because you came into this, you didn't know what we were going to ask, where your argument needed work. So a lot of times the questions are because there's a specific part in your argument that we don't quite understand. So when you go back and listen, you're going to be able to say, oh, I wasn't quite clear on that, and make it more precise. Yeah, absolutely. You're going to change and develop your argument per round.
All right. Any other questions? All right. Any questions for the coaches? All right. So I want to say thank you to all. I am going to ask you to sign out. I'll talk to the judges for a few minutes. We'll grade. Oh, I'm sorry. Go ahead. Go ahead. Sorry. There's a weird delay, so I don't hear you. I apologize for
Your
speaking.
Honor, Mr. Goodman, really quick. When will results be out?
By the end of this week.
I'm so sorry.
When will results come out?
The results will be at the end of
Okay.
this week.
Perfect. Okay.
Thank you all so much.
Alrighty.
Thank you.
Thank you so much for your time.
Thank you so much. I'm very proud of you all.
Okay.
Okay, let me turn off
You
the.
can stay.